Good evening and welcome to Lawyers on the Line. I'm Jim Balmer, a founding partner of Falsani, Balmer, Peterson & Balmer law firm and this evening's moderator. Tonight's topic is workers' compensation. When an employee gets injured on the job, that employee has the right to a number of benefits under both Minnesota and Wisconsin law. Handling medical bills and wage loss, dealing with medical providers, getting back to work, and just navigating the system can all be very complicated. Here is tonight's panel: Bob Falsani, the other founding partner of our firm, Stephanie Balmer, another partner with our firm and my daughter, and Kelly Falsani, a partner with the Fitch, Johnson, Larson, and Held law firm, and Bob's son. Kelly practices insurance defense on behalf of insurers and employers in the Twin Cities.
And you've had cases against him, Jim.
Yeah, that's true. That's right.
Yeah.
You're absolutely correct.
Yeah.
Bob, Stephanie, and Kelly will respond to your questions about workers' compensation. Please call us with your questions at 218-788-2844 or 877-307-8762. And now let's begin. My first question is going to be directed to Bob. It's this: my doctor doesn't want to get involved with my workers' comp claim. Anything I can do about that?
No.
All right. Any other input from you, Steph?
I essentially agree with Bob. You can't make a doctor do anything. You could look for a different doctor, but you might be accused of doctor shopping then.
Well, that brings up the next question, and I'm going to direct this one to Kelly. This question comes from somebody who asks, I don't like the doctor the employer or insurer sent me to after my injury. Can I change doctors?
You can.
How do you do that?
You ask to change doctors, and if you're within 60 days of the first medical treatment after your work injury, you have the statutory and the treatment rule right to do that. If that ask comes after 60 days, then it's something that you have to request to the employer and insurer through the claims representative handling your case.
Are there any pitfalls?
There are. One of those is if you choose to change a doctor 6 months to a year after treatment,
yes,
and that doctor's released you to return to work without restrictions and given you maximum medical improvement, the insurer is likely to have a bit of a red flag when you decide to do that. So if you really don't feel comfortable with your doctor right after the injury, that's the best time to ask for a doctor.
All right. So,
in real world, it's not that hard as long as it's not a critical time in the case.
okay.
I mean, as long as it's a very reasonable, good cause. My doctor doesn't like me for XYZ reasons or whatever.
As long as it doesn't look like you have some legal motive for changing physicians.
That's best, yes.
Okay.
Doctor shopping.
Okay. Now, speaking of doctor shopping and legal motives, I heard Kelly use the term maximum medical improvement. At least I think I did. What's that mean, Steph?
Maximum medical improvement, or MMI, as it's frequently called in the workers' comp field, is the point at which an injured worker is found to have reached peak recovery from the injury. It's not having been fixed. It's not returning to baseline, but it's where the medical providers look at the injured worker and say, yeah, that's as good as it's going to get. We really don't expect any significant improvement from this point forward.
Does that mean the employer or insurer no longer has to pay for medical care after that point?
The only relevancy of maximum medical improvement, which is a very common mistake that people in the work comp field make, is it can serve as the beginning of a deadline for temporary total benefits.
Temporary total benefits?
Injured workers who have been found to have reached maximum medical improvement can receive temporary total benefits for only another 90 days as long as proper notice was given and everybody was aware of it, and as long as there's no dispute over it. And temporary total benefits are one of the types of wage loss benefits injured workers can receive.
Okay. All right.
It's a critical point where there's litigation often, which is the insurance company sends the person out to their doctor who says maximum medical improvement. The treating doctor says we need more therapy, injections, post-surgical recovery, whatever it might be, and then it's a battle.
I see. Now, when you say litigation, that you're talking about the point at which somebody needs to think about calling a lawyer.
That's for sure, yes.
Okay.
Oh.
Now, here's another question, and I'm going to direct this again to Kelly because it seems to relate to insurance coverage. This person asks, I am self-employed, but I want to have workers' compensation insurance for myself, not just my employees. Do I get that automatically, or do I have to opt in for it, or is it even available to a self-employed person?
First off, it is available. Second off, you do have to opt in when you're an owner of the business, and this happens all the time. It's an important conversation for owners to have with their insurance agent and to be very clear that they want to be covered. Now, an interesting aspect to that, though, is if you're opting in as the owner of a business, whatever you make in that business or your salary from that business is going to be included in your policy. So your insurance policy, I'm not an expert in that field, is likely to cost more as a business owner if you're opting in for it.
I might add that I think that when we started this law firm, we both opted in as owners to get workers' comp coverage.
We do the same thing at my firm.
You
would
do.
be, I think, insane not to opt in as work comp plaintiff attorneys or defense counsel, given the fact that we travel for work so often. If you're in a work-related motor vehicle accident and you haven't opted in as an owner of the firm that you're in or a partner of the firm, then you're not going to be covered under the Workers' Compensation Act.
Well, I would like to give these two a chance to answer questions, but I have to follow up with that last comment. A viewer just called in this question. Does a person who gets hurt on the job have the option of filing a civil suit in place of collecting workers' compensation? Suppose, for example, you are returning to your office from having taken a deposition out of town and you get in a car crash on your way back to the office. Do you have the option of filing a civil suit?
Against the at-fault third party, you definitely do.
All right. Now, can you sue the workers' comp insurer instead of being restricted to workers' comp benefits?
You would make a workers' compensation claim.
Yes.
Okay. And assuming that it's an admitted injury, the workers' compensation insurer is going to pay your benefits, your wage loss benefits, your medical, if you need statutory rehabilitation services, that type of thing. Now, on the flip side, you can also file a lawsuit against the at-fault driver. And the work comp insurer will have what's called subrogation against that lawsuit, so they can take a statutory formula share of any settlement or any recovery you have against the at-fault driver.
But if it's Jim and Bob and we're on business and we're going to go to the Supreme Court to argue a case, right?
Right.
And we get in an accident in Hinckley going to eat some fattening donuts,
Right.
right?
Yeah. That
You're
could
driving
happen.
badly, I know,
Yeah.
and I can't sue you. I only get workers' comp.
Oh, because I'm a co-employee.
Right.
Okay, Steph, what's the difference? Oh, go ahead.
I was going to point out too, there can be a difference in the types of damages or benefits you can claim.
I was about to ask that. What is the difference?
It's like we're related. The workers' comp benefits are very specific. They're designated by statute and fleshed out by case law. And so you can only recover certain medical benefits, certain wage loss benefits, permanent partial disability, which is a percentage rating akin to it's meant to be a permanent loss of function compensation. But in a personal injury claim or a civil claim, you can claim pain and suffering. And that's a real common conversation I have with people about not being able to claim that type of damage in workers' comp.
So you can't get pain and suffering in a workers' comp claim?
No, you cannot.
Okay. Now, let's suppose, and I don't know if any of you know the answer to this question, we'll see. It's a toss-up, as they used to say in College Bowl. That's how old I am. Suppose your employer, you have a work injury on the job, your employer is uninsured, and it turns out your injury was the fault of the employer. Do you have the right to sue in district court then?
Yes.
Okay, well, so there you are, ladies and gentlemen.
You said make some short answers.
Yeah, I
Bob
know,
is
you're
being
doing a good
very
job.
good at the short and
You're doing
sweet,
a
I
great
have
job.
to say.
Yeah.
Okay, now here's the next question. Oh, never mind, we covered that. All right, now here's the next question. And we'll start with Steph this time. Do you get wage loss from day one of a work injury?
No, you have to have missed work for a certain number of days before eligibility kicks in.
How many?
3.
Okay. So if you miss work for 2 days, you don't get any wage loss. If you miss work for 4 days, you do.
Until you miss 10 days of work, then you get the first 3.
Oh, it's got to be 10.
Yeah. Once
Oh.
you get to 10, you go back and recapture the 3.
Can I
Okay.
just jump in?
Yes.
This is one of the calls we get from our clients often, how to figure out this 3-day waiting period and then the 10 days and when it kicks in and when it
Really?
can be restarted. There's tons of differing opinions. Oftentimes you can contact the Department of Labor and Industry. They'll say one thing, but then your attorney might say the other if you're a claims rep. So it's definitely something that is more confusing than you'd think.
I don't know why. I just gave the answer.
And
Just tell them to call Bob.
Because there's oftentimes people will have like a part of a day, or they've
Or there's a
they
weekend.
they were scheduled for a vacation that shouldn't count, and there's all sorts of other aspects that come into play with it. But
And just so the viewers are clear, when you get a call from a client, it's an employer. When Steph or Bob get a call from a client, it's an employee.
correct.
Generally.
Okay.
Yes.
All right. Now, here's another question. Let's see. Steph, what should I do if my boss or supervisor or lead tells me that my injury wasn't that bad and he's not going to report it to the workers' comp insurer?
You should report it to the state of Minnesota.
All right. And who do you call? The governor?
Department of Labor and Industry.
All right. Okay. All right.
You could try calling the governor. I don't know that would go very well. Yeah, I mean, go
What do you mean?
I'll
Governor Waltz?
No, it's great. I just
Yeah.
you'd have to, leave messages and
The Department of Labor and Industry is tasked with this. They have compliance division. That's who you call. But the other option is that there's people nowadays have their smartphones. They have computer access, internet access at libraries, everywhere else, right? So there's a way that you can also look up, if you don't know who your employer's work comp insurer is, you can go and Google insurance lookup work comp Minnesota or something to that effect, and it will bring you to a nifty page where you can look up your employer's work comp insurer, and then you can find out where to call.
unless that insurer has been bought by another insurer who's been bought by another insurer.
Which frequently happens. I
Yes,
suppose.
Correct.
because I use that site all the time, but the Department of Labor is even better as far as keeping up on who has the risk for what dates.
Yes.
Okay, here's a question I'll ask Bob to start with. If somebody gets workers' comp benefits for being permanently, totally disabled, for how long do they get them? The rest of their life?
No.
How long do they
Okay.
get them?
So this has been decided based upon legislative changes with sections of time, sections off, okay?
Okay.
For our purposes, and I mean, there's a few age-old cases with a different rule. Up until October 1, 2018, you get permanent total to age 67. There's a presumption of retirement. You'll be cut off at age 67, and you can fight it out,
Okay.
Bob's really good at figuring
after
that one.
after October 1, 2018, then the legislature finally figured out there's all these old people working like us.
Right.
And so they're working, into the eons here.
Right. So
okay?
suppose you get hurt when you're
Yeah.
70.
So so now the presumption doesn't, the presumption is you'd retire at 72. If you're on permanent total, you get it to 72. And if you get injured between 67 and 72, you get 5 more years no matter what
Okay.
of your permanent total benefits. But you have to win permanent total to start with, of course, right?
All right.
So which is very hard to do. But so the point is, if you're 1 minute before 72 and you got injured, then you get 5 more years, so you'd get the presumption wouldn't apply to age 77.
Now, I'm going to ask a couple
Hold on, it's not a presumption, it's a statutory cutoff immediately.
That's true, yeah.
Okay. Let me ask.
That was one of the trade-offs when they bumped it.
All right. Now, you and Stephanie are both admitted to practice law in Wisconsin as well as Minnesota, true?
Correct.
Yes.
Are you?
I am.
Oh.
My focus is Minnesota, though,
All
so
three of
I'll
you.
defer to that.
Okay, all right. So here's a question. Is it easier to qualify for permanent total disability in Wisconsin or Minnesota, Stephanie?
I would say, depending on the injury, it can be.
In which?
In Wisconsin.
Okay.
Sorry.
What's your answer to that question,
I'll
Kelly?
defer to Bob.
Okay, what's your answer, Bob?
I'd say Minnesota has traditionally been easier. Minnesota has special hoops like thresholds. You have to have a certain amount of permanent partial disability in Minnesota. But Wisconsin, to be permanent total there, I mean, you might find one under a rock somewhere, but they're very hard to find.
Speaking of hoops, here's a question. I'll start with Stephanie on this one. Workers' compensation insurer wants me to jump through all these hoops just to get my pain medications. Is that legal?
Well, I imagine that's referring to some recent changes in how narcotics and opioids are administered. The workers' comp system has responded like everybody else has to the opioid epidemic, and there's been some statutory or rules implemented to allow adjusters and insurers to have a little bit more control over how these medications are administered and make it easier for them to make sure they're not being misused or prescribed in a bad situation.
This is a response to the opioid epidemic?
Yes.
Okay. Now, here's one I'll ask Kelly. Well, Kelly, and then anybody else could jump in. The question is, I sustained a career-ending injury on 12/1/2018. My rehabilitation consultant says that if I take a lesser-paying job, I should qualify for 2/3 the wage difference between my date of injury wage and the wage I get from the new job at the Portland malt shop. How long does that last?
If your injury was on December 1st, 2018, that is temporary partial disability benefits, and that has now increased to 275 weeks that you can have it. But the time frame is that 275 weeks has to be exhausted, or you have to have used that within 8.33 years or 450 weeks.
Okay, well, okay, so how many years is 275? Is that roughly 5.5 years?
Correct.
Okay.
But the statute has a cap of 450 weeks so that folks will have a time frame to use it, but they can't use it forever. Now, getting back to the permanent and total disability conversation we had, they used to have, I think, temporary partial disability, which there wasn't a cap on how long after an injury you could.
Way long time ago.
Yes, exactly.
Yeah.
Before I was.
And it's been 225 for a long time, since 1995.
So now it's gone up.
Yes.
Okay, increased in duration.
But it's not retroactive. So, in other words, if you were injured September 1 last year, you got 225.
The law in force on the date of the injury regulates what your eligibility for benefits is?
Generally.
About 99% of the time.
It depends.
Yeah.
Okay.
But yes, for wage loss benefits, yes.
Not necessarily for medical benefits.
Well, I mean, a lot of the medical benefits depend on. I mean, the statute for medical benefits hasn't changed much, but it's a reasonable necessity is the general rule. There's treatment parameters that there can be departures from them, and they're more of a governing framework. But if you have reasonable and necessary medical treatment that's causally related to your injury, generally it's not going to matter when that injury occurred.
You disagree?
Well, before they put the parameters in, it was open season. You know, you want to go to the chiropractor 9 million times. You know, if the judge said it was reasonable, that'd be fine. Now there's a presumption that wouldn't be reasonable.
After a certain number of treatments.
And then you could still fight it out, but the defense has a big advantage because they have that, regulation that.
So the reference here is the 12+12 rule for chiropractic treatment.
And that only applies as long as the employer-insurer is accepting responsibility. Sometimes when we're dealing with denied medical care, we have to remind the employer-insurer that you can't have your cake and eat it too. You either are paying on the medical, in which case you get to invoke these treatment parameters and try to limit some of the treatment. Otherwise, you
Except
don't.
for the new case.
Except
from 2 weeks ago.
yeah.
Well, yes.
We're agreeing on that one. So
Yeah.
we're on top of that.
As of 2 weeks ago.
Yeah.
Okay, now I get the impression from what you three are saying that wage loss benefits are an important component of the workers' comp system. Typically, are the wage loss benefits you receive for a work injury dependent on what your wage at the time of the injury was? Steph, we'll start with you.
Yes.
All right. Now, Kelly, do unreported tips count as part of an average weekly wage for the purpose of computing wages for workers' comp
It's like
benefits.
law school.
Not from my perspective, and I'd be afraid of a tax court situation for that injured worker.
Okay, so if they claim a bunch of stuff they didn't tell the United States government about, the United States government might want to have a chat with them.
Yeah, and that's going to be public. I mean, it's going to be disclosed through litigation or providing that to the insurer. The general rule is report your tips and don't commit tax fraud.
Well, that wasn't my general rule when I was a bartender and a waiter.
Yeah, and I worked with you at Grandma's. I would like to see your tip reporting.
But anyway, the exception is this: if somebody gets hurt, right? They
Yeah.
come into my office and they say, you know, by the way, I was making $10,000 a year at this beautiful restaurant and a high-end job as a bartender or waiter or whatever, okay? And I reported 3,000, but I got 7,000 more income, and comp's only paying me on the 3,000. And you know, what should I do here? And you know, if the taxes haven't been filed yet,
Yeah.
Then you can,
Still time.
time to file your taxes. So,
okay.
you know, put it on your taxes. Then you got standing to make the argument. On the other hand, you know, if the person comes to me 2 years later, you know, I made all this, too bad you filed those taxes already. We're not going to open that up.
And
Just ask the federal government to prosecute you.
the question was about unreported tips, and I think now, at least, a lot of restaurants, bars, are doing a much better, and everything's through, not everything, but credit card payments. So that's tracked a lot better than it was back when even I was working as a bar back at Grandma's, or when you waited tables in the Stone Ages. So I mean,
Yeah.
nowadays there's not as much.
We didn't
of that
even use
difference.
implements to eat in those days. You know.
Yes.
Right.
There's not as much of that going on, at least at places that are owned by restaurant groups and that have sophisticated systems to track tips.
That is better.
Okay, now here's two questions, and we'll start with Steph on one and then go to one of you two with the other. First question, if an employee gets hurt on the job, but it's actually his own fault because he wasn't wearing the proper safety gear that was required by the employer, does he still get workers' comp benefits?
Who's sending these questions in?
It's my work comp professor. It would depend on the situation and the safety gear and what he was doing. You know, the rules about what is and is not a compensable injury are meant to be a no-fault system. In other words, there isn't meant to be a lot of finger pointing. On the other hand, I would say generally, yes, it's still compensable.
So even if the injury is the fault of the employee, he still gets benefits, except in some situations.
Well, when you say the fault, I mean, there's a line where if the person was intentionally breaking a very significant rule, you know, that gets a little more clear, but.
Correct. Jim.
Bob,
If you want clarity, you read the case of Brown versus Arrowhead Tree.
Yes.
I lost 5-4 in the Supreme Court.
Right, I was going to mention that
and
case.
it's when the employer says, "Don't do this.
Yes.
This is not one of your job duties. Don't do this.
You might get
You know,
hurt.
and they say it right before this happens, and it's really dangerous. Don't do this. It's really dangerous. And then you do it immediately after that. Okay. Then you probably aren't getting your comp. At least I didn't for that case.
If you have a policy in place as an employer and you follow that policy, if you say you do not step out onto this ladder or this roof or whatever without putting on the safety harness, and if that person or if other employees have done that and then you've disciplined them, or gone through the progressive discipline or had docked pay or whatever it is, and you follow that as an employer, and then that person disregards that rule and then is injured, then you do have a likelihood of prevailing as far as the employer and insurer on a prohibited act defense.
Well, if I'm representing the employee, you win that every time. But yes, I understand what you're saying. There's going to be trouble.
Let's flip it over. Now let's say that the employee gets injured because of some stupidity on the part of the employer. Suppose it's a two-man operation, the employee is doing his job and the employer doesn't pay attention to what he's doing and he runs over the employee's foot with a piece of equipment. Can't the employee sue the employer for pain and suffering? Steph, we'll
I
ask.
wouldn't say in that situation.
Okay.
No.
All right. So he's barred despite that. All right.
Yeah, there's this terrible case where the employer sent an employee into a caustic tank that was unbelievably dangerous. and said, you don't need this respirator. Just go in there and clean this out. Just don't breathe too deeply. And the guy fried his lungs, almost died, and was terribly disabled, okay? No case, they threw it out.
All right, couldn't sue the employer for that, despite the...
Threw it out of court.
Okay.
Shameful this result, but that's what happened.
Okay, okay, I got to follow. I guess that's all the time we have for tonight. There's all kinds of questions I wanted to ask. That's all the time we have for Lawyers on the Line tonight. Thanks to our guests and to all the viewers who called in with questions. I'm Jim Balmer. Join us again next week for a conversation about Social Security. Good night.